Hi, I'm Peggy Kirk, and I need to speak with you a little about something that is very important, and that is the different categories of authority. We are going to be really spending a lot of time on this subject because it is very important that we understand the different categories of authority and how we may use them. I would like to explain we have three basic categories of authority. We have non-authorities, secondary authorities, and primary authorities. The non-authorities are not law. They are not things written about the law. They are simply finding tools. They are things that are written to help us locate law and or secondary authorities. And these would include things such as digests, which help us locate law in reporters, since reporters are arranged chronologically, and the digests arrange references to case law by topic. Then we also have indices, or an index for a code or for statutes, and even things such as administrative regulations and rules. We also have another really important set of books within this particular category, and that is that of Shepard's. Shepard's is a set of books which allows us to validate the law we have found. It tells us how other cases have treated our particular authority and tells us whether or not it is still good law. If we are, of course, doing our research online, let's say with a paid subscription to something such as Westlaw or LexisNexis, we would have Shepard's online. And it may be called Shepard's, it may be called Keysight, but essentially it works the same. It helps us validate what we have found. Our second category of authority is that of secondary authority. And secondary authorities are things that are written about the law. They are not law. They are only written about the law. And we use secondary authorities to help us to understand an issue and to help us perhaps narrow our issue so that we can find actual primary authority. Secondary things would include such sets of books as perhaps an encyclopedia, the ALR, dictionaries, any type of horn book, anything written about the law, even including things such as magazine articles or newspaper articles. And it also includes things such as dictum and dissenting opinions, things written about the law. Our last category is that of primary authority. Primary authority is valid law. It might be case law, it might be a statute, it might be a code, it might be a constitution, it might be a local ordinance. Any type of actual law is primary authority. Now, we learned a little bit about the doctrine of stare decisis in P1, and we also learned a little bit about court structure. And even though those are probably subjects that make most people want to fall asleep, they're very important for us to understand because we have to understand our court structure in order to know what kind of authority coming from what court or court level is going to be something that we can use as primary mandatory authority. And that is something that a court is going to be required to follow, as opposed to persuasive authority, which is something that a court may follow if it would like, but is not required to do so. So we have to think really hard about our court systems. For example, I live in Texas, and so if I find a wonderful case that I want to use to support the position I'm taking in a Texas court, a Texas trial court, and let's say I find a wonderful case that is from a higher court, but unfortunately it's from New Mexico. Is that going to be primary? Yes. Is it going to be mandatory? No. It cannot be mandatory because it is not from a higher court within my state's judicial system. So it would be persuasive. It would be something a court might follow if it would choose to do so, but is not required to do so. I would have to find a court opinion that would be from an intermediate appeals court within my state, or my state Supreme Court, or my state's constitution, or my state's code, or the United States Supreme Court opinions, or the United States federal constitution, or the United States federal statutes. Those things, the federal constitution, the federal statutes, the opinions of the United States Supreme Court are mandatory authorities, if they're on point, for all jurisdictions. Now, if we happen to be in a federal trial court, we need an opinion from the Intermediate Appeals Court on the federal level. We need an opinion, let's say, from the United States Supreme Court, or we need something from the United States Constitution, or we need something that would be a federal statute. And it's not always easy to find, by the way. But let's say, for example, I am in a federal trial court in Texas, so I am in the Fifth Circuit. So if I find a wonderful case that happens to have come from the 10th Circuit Court of Appeals, federal court, it would not be mandatory for my court to follow. It would be persuasive because it is not from my federal circuit. So we have to understand how the courts are broken down. We need to understand what particular circuit or district or whatever we are in within our state, within the federal systems as well, in order for us to know when we have found something that is going to be mandatory for a court to follow. Another thing I need to talk a little bit about is the difference between an official reporter and an unofficial reporter. The basic difference is one is published by a government printing office. The unofficial is printed by a commercial printing company. Now, it is important to understand that the actual opinion itself is word for word the same in both kinds of publications. The big difference is that the commercial publication is going to have little finding tools for us and other little things to help us. There are headnotes in the unofficial. These headnotes are brief little summaries of issues of law that the editor found to be important within that particular opinion, and they are indexed in a digest, which then helps us to be able to locate something in sets of books, because reporters are arranged chronologically as opposed to by topic. So the digest is arranged by topic and helps us locate a citation to a reporter, so we are not going page by page, date by date, looking for a topic. We could spend the rest of our lives doing that and never find anything. So it's important to understand there is not a difference in whether the opinion itself is correct or word for word the same. They are the same. It's just that the unofficial have other little helpers stuck in there. We have annotations in the headnotes and other little editors, things for us to help us in our research. I hope this has helped some. Please go back and review court structure. If you're not really clear on it, please let me know if you have any problems or any questions, because this is very important to understand. It is very confusing at first, but believe me, it gets a lot easier with practice and time. Thank you so much.